directly when they deal with constitutional interpretation. If it's a matter dealt with by the Court of Appeal involving interpretation of the Constitution, an appeal lies as of right to the Supreme Court. On the other aspects of the jurisdiction, it's a matter of public interest, and I think the Supreme Court has dealt with that.
Now, just on that small issue, you said public interest. I think the word used there is of general public importance. What to you is the difference between a matter of public interest and general public importance, and how would you distinguish the two?
Public interest can be compartmentalized. You can dissect it, because you can have NGOs coming in the name of public interest, but they are serving their own sectional interests. General public importance is wider. It covers, as you read this issue, it seems to be affecting the general public, like BBI. If an issue is presented before the Supreme Court relating to BBI, having come all the way from the High Court to the Court of Appeal, it will be a matter of general public importance. So to me, public interest is narrower compared to general public importance.
And what is the test? What is the test in your view? How would you distinguish the two? Because that is where the meat of the Supreme Court jurisdiction is vis-a-vis the Court of Appeal. How would you distinguish the two?
The short answer to that will be, it will all depend on the issue itself and the objective interpretation of the court, because I cannot perceive an issue and say this is general public importance. For instance, if it's a nationwide issue, which is the concern of the general public, like I'll give an example, like if an issue, somebody was to say Kenya should no longer borrow from the IMF or from whoever, and goes to the Constitutional Court, and an appeal is taken to the Court of Appeal, that is a matter of general public importance. That is an example.
Any cases that come to mind?
I'm giving because there isn't. I'm giving an example that.
I mean, because yes, what I want to know is the test, because part of the complaint you will hear out there is that the Supreme Court came to solve all our problems, isn't it? That why do we have a Supreme Court, yet it is not hearing our issues? So 164 has said, no, we are not dealing with everything. We are dealing with issues of general public importance as opposed to public interest. So one of the things you will be dealing with on everyday basis is, how do we distinguish these two streams? That this one, go home, it is public interest but not general public importance. And this one may be of general public importance, but the public has no interest.
There is no one answer to that. I will lie to you to say this group of cases belong to general public importance, and this one, because it's initiated by lawyers or by an NGO, it's a matter of public interest. Okay. It will all depend. My answer is this. Honestly, it will all depend on the problem itself.
Okay. There are many decisions of the Supreme Court on that. Next question, and just as I'm finalizing on this aspect, one of the issues that concerned me when you were starting, and this goes, you've talked about a backlog and dealing with backlog, and thank you for exposing some of the problems we face. One of the issues you said that, which I caught, is that you worked yourself to the extent of becoming a diabetic. Now, my concern is this, room 17, you are holding 5 hats. What fear, should I fear that those 5 hats will cause you to aggravate your diabetes? And what is it you will do to avoid this kind of situation?
Okay, I think the bigger problem is the induction. When you are inducted, that time you are not warned against overworking yourself. And that is a bigger problem. I think some of the committees came up with the issue that newly recruited staff should be inducted. I'll give you an example. On a Thursday when I had confirmation of grants, I would sit from 9 to 3 without even taking a break. I've learned my way in the judiciary that you need to take a break after maybe 2 hours. And the many hats, these many hats will not come when I'm just seated in the office doing the work of many hats. You'll have to go out, interact, you have to come for a meeting and deliberate on issues, so it's not an issue that one has to do this work whether you are diabetic or not, whether you are epileptic or not. Those are conditions which are there. But I've learned from the hard way how to handle these many hats. That time, I think I was overworking myself, no exercise from the office, to go and sit and write judgments up to maybe midnight in the morning. You wake up by 5, you are definitely will be sick.
Thank you. And finally, I think in one of the papers today, and since this COVID started, the issue of domestic violence has gained a lot of prominence. What do you see is the role of the CJ dealing with the problem of domestic violence?
Okay, domestic violence, I believe, is related to the family, not mainly husband and wife. Even children are affected by this violence. It's not a Chief Justice only problem, because those involved have to be arrested and prosecuted, and the cases fast-tracked so that if one is convicted, it can send messages to those who are involved. There are already cases in court, people chopped off their hands and convicted. So the role of the judiciary and also of the CJ will be to ensure that whoever is implicated in this is prosecuted. But I'll have another angle to this.
Let me just ask, is there any of the hats you're wearing that focuses on this particular issue?
Yes, there is the hat of being the head of judiciary, and the hat of National Administration, Council of Administration of Justice, where other sectors in the criminal justice or the justice systems are involved. It can be discussed there. The CUCs, that's where I was heading. Sometimes you can see prevalence of an aspect of criminal law, and you go out and educate the people. I remember we used to have so many outer talks in Kakamega in conjunction with the county government. Cases of forest, people being charged with taking wood from the forest, will go near the forest and talk to them. The implication, the cases will reduce. So if, as the chair of the National Council on Administration of Justice, we can rope in the prison, rope in the DPP, and sort of sensitize the public that domestic violence is becoming rampant, and we should know how to deal with it. I think the CJ has a role there to play.
And finally, in terms of that same issue, what do you think, the same issue of domestic violence? Now we have the COVID situation. We have operations of the courts have been affected. What kind of interventions would you look towards enhancing access to justice in that particular sphere?
We have had COVID. The courts are working. Those arrested are taken to court. I know the prisons have been a bit hesitant to take suspects up to open court. We have technology. So as the CJ, I will try as much as possible to ensure that it has worked. All what we can do is to enhance the technology. It has worked. A plea can be taken from the prison as one sits in court, and the prosecutor is in his office. So it's not that we will relax. We will ensure that technology takes over and these cases are heard.
Thank you, my lord. Thank you, Chair.
Thank you, Judge. We are going well. Judge, you can have a sip of water. It's 2 hours. I will now request Honorable Commissioner Machadi Ajero to ask you some questions, and then after that you have Honorable Commissioner Evelyn Orwade to ask you further questions. Thank you.
Okay, thank you, Chair. My Lord, now let us start on this issue of jurisprudence and your legal philosophy. Now, I read this decision that you made on the Council of Imams and Preachers of Kenya in Malindi, where you were clear that a child cannot be married off because that would not be in line with the Constitution. You extensively made reference to the Constitution. Now, my first question would be that why I took interest in it, the fact that you are a Muslim yourself. Now, how do you handle matters that where your Islamic faith may necessarily not agree with the strict legal provisions of the law? How do you balance that out as you are applying the law, even as maybe sometimes you may not, it may conflict between your religion and what the law states?
I think the Constitution is clear that there is no state religion, so that's the starting point. So when it comes to making decisions, they should be purely based on the law. I'm sure there are certain aspects of the law when they will be brought to you, and you can see that on the one hand, the religion allows, on the other hand, the law says this. That was one aspect, and even at the back of my mind, I knew that those people who filed that case knew that I'm a Muslim, so let's go to this Muslim brother of ours and terminate this criminal case, because he will understand that from time immemorial, under the Islamic faith, a girl of 16 years can be married off. But my view is, first and foremost, you look at the law. And those who married off the 16-year-old girl knew that they are living in Kenya. In fact, I explained that when you are living in a country with the laws, the law comes first. Then the religion will follow. It's not that you are being restricted. You know, there are those issues like a law is passed, don't pray. That will not be law, because it will be contrary to the Constitution. The Constitution acknowledges the freedom of conscience. So no law will be passed that don't go for your Friday prayer. But when now these are purely personal aspects of saying a girl of 16 years can be married, I am a Muslim, it's true. In other countries where they don't have certain laws like Kenya, where the marriageable age is 18, they exercise it. But I will go for the law, because if you go contrary to that, you will be setting a precedent that Muslims in Kenya can marry at 16. And I don't think that is the intention of the law.
Okay, thank you, Honorable Judge. Now, then that brings me to the second question of the issues of judicial activism, where there will always be a conflict between the three arms of government, each saying that this is my responsibility. And I want to specifically come now to the issue of legislature, because this is something that keeps arising, where the legislature will say that it's our responsibility to pass the laws, just like you've indicated. Then, on the other hand, you find a party who comes and challenges that law, and now it becomes the responsibility of the judiciary to interpret. Now, oftentimes there's this conflict that arises, that this judicial overreach. Now, what guides you as a judge, and what are your views regarding that? Because yes, the legislature sometimes will also overreach themselves in passing the law, but they'll say that we are the people's representatives, that's our responsibility. But again, now if the judge comes to a decision that seems to overturn that law that has been passed, again the legislature will say this judicial overreach. I don't know, what are your views regarding it, and what guides you as a judge, and what to be your role as the leader of the judiciary if you had become the Chief Justice in dealing with those aspects?
These are not gray areas. They have been with us. And the work of the judiciary is to interpret the laws as they are passed by the legislature. And the main focus here is the Constitution. The judiciary will pronounce itself that a certain aspect of the law is unconstitutional. There is, in my view, that is okay, because it's the duty of the judiciary. We can't say that there is the general presumption that all the law passed is in compliance with the Constitution. But when it's analyzed, it's found that it is not. And it is the duty of the judiciary to punch holes to the law which is unconstitutional. However, we have had courts declaring certain aspects of the law as unconstitutional, but they still remain in the laws. I think there is need to come up with an approach. I have also said in the judgment, one of the judgments Commissioner Majanja referred to, one judge will say this is unconstitutional. Another judge says it's not, like in the aspect of Section 40 of the County Governments Act. So, what should the legislature say? Should they follow the one who says it's unconstitutional, or should they follow the one which says it is constitutional? So there is also need to come up with the areas, with the improvement on this declaration of unconstitutionality. It is true this is a conflict. It's not an overreach. I will not call it as an overreach. It's a responsibility, because the judiciary is there to interpret the law. But there is that need of finality, so that actually when we say this section of the law is unconstitutional, in my view, there should be an automatic picking of that declaration by another superior court, so that it can consistently be held to be so. So that I, as a single judge, does not say that a section of the law is unconstitutional. It's left like that. Parties refuse to comply with that. Yet, maybe on appeal, it would have been overturned. So there is, it's becoming a bit confusing, and also the Parliament might wish that why can't this aspect be cascaded to another court, so that there is that finality that actually this is unconstitutional. It's true, we can say there should be finality in litigation, but when it comes to declaring law which has been passed by over 200 legislators, I sit there as a single judge. It's true I'm the expert in interpretation, I say so, maybe 3 wise men would rule otherwise. There is need to manage this aspect.
Okay. Now, coming to that issue that you've just mentioned, where you have different judges coming to different conclusions, or even sometimes, and this is something that I've seen as a practitioner, for instance, in an employment court, where you find a decision has been made by a court of appeal clarifying a position, but still the employment court goes ahead and goes contrary to it. Now, I wonder, as a Chief Justice, in as much as it is not your responsibility to interfere with the decisional independence of the judges, but for purpose of enhancing kind of uniformity, or where this certainty, as is being said time and again, I don't know what steps you take as the leader of the institution to guide that, that process of creating certainty, where different judges are not making different decisions over the same issue, or Court of Appeal has pronounced itself, then you find judges are going against it, or Supreme Court has pronounced itself, then others are going against. I do not know what steps you take, clear steps.
Okay, thank you, Commissioner. As the head of the judiciary, because these things come to the limelight, they are not secret. We normally have the yearly colloquium where we discuss emerging jurisprudence. We invite one of us to discuss. So, first and foremost, to disobey what the Supreme Court has said, yet the law requires that all superior courts be bound by the decision of the Supreme Court, will be now to dwell on, cannot say impunity, but dwelling on something else. Equally, to disobey what the Court of Appeal has said as a High Court judge, and to say, these judges, let them say what they said, let me continue saying what I've been saying, would also be to ignore the issue of judicial precedents and the hierarchy of courts. Because why did this party appeal to the Court of Appeal? So to solve these problems, it needs, first and foremost, to bring together, like if we can have a colloquium of the Employment and Labor Relation Court, and tell them that you are creating confusion in the jurisprudence relating to this aspect of the law, and we deliberate on it and tell them that the Court of Appeal has guided you. So can you follow what the Court of Appeal is saying? Because it's not a matter of, you can have your own personal views, but it is a requirement that you respect a higher court. So I would be engaging the individual courts and all the judicial officers, because the magistrates are ready to embrace what the High Court has said. Why can't the High Court and courts of equal status embrace what the Court of Appeal has said? And why can't the Court of Appeal embrace what the Supreme Court has said? So I would, we will now come, we can even have a catalogue of conflict areas. There are even conflicts in the Court of Appeal. I've seen, as I was in Meru, there is the issue of, under the Wildlife Act, if you are attacked by a buffalo, that act provides for a system where you start from a committee at the district level. But that process is not working, so people are going directly to the court. And there is a decision by the Court of Appeal saying you should start from that lower court, lower tribunal or committee, and there is another decision saying you can go directly to court. So these are issues of conflict, of application of the law, and they can only be harmonized. Maybe, like if it was a 3-judge bench of the Court of Appeal, if another issue arises, I would discuss with the president of that court to have a 5-judge bench, which can be seen to be more balanced and more pronounced, and rectify the situation. So I do agree that those instances are there, and it is for the judiciary itself and not somebody from outside to sort this one out.
Now, let us come now to